Uber has been fighting a test case on the status of its UK drivers since 2015. Now, the drivers say, we are workers and we're entitled to holiday pay and minimum wage. But Uber says, you drivers are little business owners and Uber is merely a booking app, so you are entitled to nothing. Now, the Employment Tribunal was unimpressed. They said the notion that Uber in London is a mosaic of 30,000 small businesses is, to our minds, faintly ridiculous. Now, that case went all the way to the Court of Appeal, which ruled in favour of the drivers by a 2-1 majority, but the court's judgment was scathing. Uber, they said, you're getting private hire licenses for London by saying that you're a private hire company with drivers, but you're trying to diddle them out of rights as workers at the same time. Try again, we ain't buying. Nevertheless, Uber has ploughed on with a psychopathic self-confidence to the highest court in the land, the Supreme Court. On Friday, the 19th of February, Uber made the clean sweep. 4 losses out of 4 goes. Its drivers are workers, say the Supreme Court, not mini business owners. And now it's got a whole load of holiday back pay and minimum wage cash to pay out, going back several years. So who's right and who's wrong? Is it hands off my Uber? Or is this a great victory, not just for Uber drivers, but for workers in the gig economy as a whole? Hold on to your brains, tech bros and tech sissies. We're going in deep. It's law cracking time. So in 2015, a number of Uber drivers backed by the GMB trade union brought a claim against Uber. Now, the GMB union is 130 years old and was founded by this lady, the daughter of this man, who is very famous because, as you can see, members of the younger generation, his beard is lit. Now, this claim has been brought initially by 2 firms of solicitors, one called Lee Day. Lee Day are the ultimate class action lawyers in the UK. They've got settlements for elderly victims of British torture in the Kenyan Mau Mau uprising. They've got settlements for former workers of the Sellafield nuclear plant who got leukemia. And they achieved settlements for 10 Iraqi prisoners who were tortured by British soldiers in the Second Gulf War. Lee Day are not lawyers who mess around. Alongside them were the firm of Bates and Wells and Braithwaite, who by the sound of their name clearly have Charles Dickens, Rumpole of the Bailey, and other legal types on speed dial. The big question for the courts has been this: are these drivers classed as workers or self-employed? Because if they're workers, the law says they get holiday pay, they get minimum wage, they get whistleblower protections. It's a big question, because Uber does this all over Europe and the world, and the outcome could have consequences. Uber's not the only company, of course, who employs people on a self-employed basis who would be a lot better off financially if they could claim to be workers. Now, a second question, which is also very important, is what counts as working when you're an Uber driver? Is it the whole time you're logged into the app and ready to take on journeys, or is it only the time you're actually driving a passenger around? Now, this is really important if you're a driver, because if the UK courts say that you count as a worker, all those hours of back pay on minimum wage and all those days of holiday that you've been stacking up for the last 6 or 7 years start looking a whole load more chunky, a whole lot quicker, if all that time that you're waiting in a lay-by in limbo for the Uber gods to send you another punter counts as well as the time you're actually driving. Uber say, as they always say, we're just a booking app. Really, we're a technology company, not a transport company. They also say, we have terms and conditions that the driver can choose to accept and work with us or choose not to. And they say that you are self-employed. Clause 4.1 of the driver's service agreement says, once you are booked, we are out of the contract. We help you collect money as if you were collecting it yourself. It also, in its terms for passengers, makes it clear that their contract is with the driver. Uber only takes the booking. Now, obviously, the drivers want to be treated as workers, but what does the law say? So according to a definition coined by Baroness Hale in a case called Bates van Winkelhof, there are 3 classes of person who do work. Baroness Hale, Lawcracker, met her once on the train, thinking she was a little old lady. She was holding 2 coffees, which Lawcracker, being a gentleman, offered to carry for her. It became apparent on the journey from Costa to the train itself that not only was she with her husband, but this little old lady was in fact Baroness Hale, the President of the Supreme Court. It was slightly weird, but at least nobody knows about it. So Baroness Hale says the three categories are these. Employed people under a contract of employment, well, that's easy. Self-employed people who are in their own business, working on their own account and working for clients or customers. And an intermediate class of workers, guys in the middle who are self-employed but provide their services as part of a professional business undertaking carried on by somebody else. Now, you get none of those workers' rights we've talked about if you're genuinely self-employed. If you're a salaried employee, it's easy. You get employment law rights, we all know that. But if you're in the middle, doing work, for example, on behalf of a single company, you do get some employment law rights. Now, this protects people who work for cleaning companies or care homes who are often quite vulnerable in the job market, so they have some rights, even if their contracts are written to look more like they are working on a self-employed basis. Now, what decides if you're a worker? It all comes down to the concept of control. If you're self-employed, but the customer you're selling your service to has control over you, you're much more likely to be considered a worker with workers' rights. For this final Uber judgment, the UK Supreme Court has called upon its French-speaking homies from the Supreme Court of Canada for a definition of control. And those Canadian judges say the more the work life of individuals is controlled, the greater their dependency and consequently their economic, social and psychological vulnerability in the workplace. Now, Uber says our guys aren't vulnerable. They are running their own businesses. They decide when they work and when they don't work. They have a lot of freedom like that because we're nice guys. So is Uber right? Or does it have control over its drivers? Well, the Supreme Court judgment agrees that Uber doesn't decide when its drivers have to work. They can log on and off, but seasonal farm workers picking fruit in the summer can come in and out of employment when they want, but the law says they're still workers. The Supreme Court goes on to say this: Uber controls how much its drivers are paid. It fixes its cut at 20%. It also decides whether to give refunds and charge them back to the driver. The contract terms are fixed by Uber. If a driver doesn't like them, Uber says it's my way or the highway. The highway is... Another method of control that the Supreme Court has identified is driver ratings, which are an internal record for Uber. If you don't keep them high, you're kicked off the platform for good. And this is used, the judgment says, as a basis for making termination decisions, and is a form of classic subordination that is characteristic of employment relationships. Now, the second category, control, is that although a driver can decide what area to work in, he or she can't decide in advance to reject a ride based on where it's going to. And that's because the driver isn't told until after accepting. Thirdly, if a driver rejects multiple requests for a journey, he or she will be logged out of the system, banned in effect for a period of time, and this is a penalty. 4, Uber dictates the type of car a driver must have and also the route that he or she takes, and if he doesn't take the route, there's a risk of a penalty. 5th, restriction of communication, and this is the slightly weird and gaslighty part of the Uber driver relationship. It's not possible to exchange details for passenger and driver at any point. Passenger cannot choose that driver or other drivers. The collection of fares is nothing to do with the two of them. It's all done by Uber. Even complaints are handled by Uber. Now, hang on a minute. If that's the case, how is it that Uber can say we're just a booking app service? Surely there must be some kind of agreement between the driver and the rider resulting in, an invoice. And here we have another example of when innovation in tech crosses into a pretty obvious and kind of sordid attempt to manipulate our perception of common sense. Ladies and gentlemen, I give you the Uber Invoice. Now, the Supreme Court describes an Uber invoice as an electronic document, although styled as an invoice from the driver to the passenger, is never sent to the passenger, and though available to the driver, records only the passenger's first name and not any further details. So let's break that down from a customer's point of view. You're hiring a service from a driver whose full name you never get to know and you never get an invoice from them, but it's okay because Uber's responsible for it. So that's how you're protected. But Uber isn't the company you're getting the service from. Struggling? Don't worry, Lawcrackers. The Supreme Court struggled a bit with that too, but for the driver, it's way more nuts. Uber say, it's your own business, but we dictate charges. We'll kick you off if you don't behave. Use the car we specify. You can never speak to any customer we send you ever again. We'll give you an invoice between you and the passenger. What do we mean by invoice? Well, it will say invoice in big letters at the top. It will just have the passenger's first name, which unless they are Sting, could be a problem if you want to expand your business relationship or ever speak to them again. Well, in conclusion, given all of these elements of control, the Supreme Court barely hid its disgust at the idea that Uber claims its drivers have their own business. It said drivers' inability to offer a distinctive service or to set their own prices and Uber's control over all aspects of their interaction with passengers means that they have little or no ability to improve their economic position through professional or entrepreneurial skill. And here, Lawcrackers, is the depressing, almost dystopian reality of what being in your own business in partnership with Uber actually means. In practice, say the Supreme Court, the only way in which they can increase their earnings is by working longer hours while constantly meeting Uber's measures of performance. Now, Uber tried to make arguments to the Supreme Court about cases of other cab companies and even a case about a stripper. Well, the lords and lady of the Supreme Court were not particularly impressed by that. But what of Uber's famous terms and conditions with drivers? Remember that? You're not a worker, you're self-employed, you agree that we are just a booking service. Can a company use a contract to remove worker status out of an employment situation? Well, the Supreme Court chose its words with a hint of sarcasm, you may feel. Uber has to confront the decision of this court in Autocleanse versus Belcher. Confront. That's a hell of a word, isn't it? In fact, the use of that word by a Supreme Court judge suggests to me that Uber may not find such a confrontation particularly pleasant. And the Autocleanse case said this: the relative bargaining power of the parties must be taken into account in deciding whether the terms of any written agreement in truth represent what was agreed. Translation: if you're a taxi driver in an agreement with a multinational tech giant like Uber, they can't just say you're not a worker in the contract. If you're a worker, you're a worker. And all the fancy contract terms gymnastics in the world can't get Uber out of it. Finally came the issue of being on call and logged in and whether that means you're working. Well, even if you say these guys are workers, they are only workers for the time they're actually driving a passenger. That's what Uber's lawyers said. And why were they so keen to say this? Because minimum wage and holiday pay while you're logged into the app is a much bigger payout for drivers than minimum wage based on when you're actually driving. And it's been said that there's a pretty sinister reason that this is important to Uber's business model. Uber needs a surplus of drivers in any locality to have a business case. That way, they can outgun the opposition. They can afford to do that if those drivers working for them in that locality, waiting for jobs, are on less than minimum wage for being available all the time. And that means Uber can more easily see off competition from conventional cab firms. Now, the Supreme Court's ruling was predictable because there is long established law on this. If you're on call to do even some work, you are working. And this is what some old guy called Lord Justice Stevenson about 30 years ago called an irreducible minimum of obligation. Now, while that phrase sounds like what someone in a Jane Austen novel would call having to do a bit of work, that's okay, because that's basically what it is. If you're a driver logged into the app and you're obliged to take at least a proportion of the offers of rides that come in, or you risk getting kicked off the app or there's other penalties, that's at least a minimum amount of work. And even Uber calls logging into the app going on duty. Lawcracker's verdict is that it is ludicrous to suggest that this means you're not working, and predictably, Uber lost this point too. So, what from here? It's a loss in the Employment Tribunal and 3 strikes and out in the High Court, Court of Appeal and the Supreme Court itself for Uber. We can now say it's the end of the road for Uber and its fancy driver contracts, at least in the UK. Bear in mind, though, that the legal basis for most of this was European workers' rights law, so Uber's illness might be contagious to other parts of its organism in other countries. Of course, the UK Uber drivers can claim holiday pay and recalculations to get minimum wage going back several years, and it also probably means the business model of swamping the market, especially in London with these low-paid drivers, is no longer such a viable option for Uber. Now, that is a good thing probably for drivers. It's certainly good for the other private hire and black cab outfits who will find it easier to compete on what is probably a more level playing field. But this decision goes much further than that. There are other tech companies who use smart contractual terms to try to treat workers as self-employed people while at the same time controlling how they work. The Supreme Court and all the lower courts who came to the same conclusion have drawn a line in the sand for tech companies who want to try to innovate their way out of workers' rights. Lawcracker reads this judgment in this way. The courts have decided that the gig economy is at least partly based on abuse of workers. And even grey-haired judges in their Harry Potter outfits say that this abuse is against the law. This was the Lawcracker. Tell me what you think. Like, share, subscribe, talk to your mother-in-law about me. Whatever you need to do to promulgate the message of Lawcracker. I'm interested in what you think about this video. Is this the beginning of the end for humanity? Is this all about robotization of the things that make us humans? Are we being turned into slaves like in the Matrix, except kind of in a less cool way and with no kung fu? Guys, let me know what you think. We're up to about 92 subscribers as I'm recording this. It would be great to get to 100. If you're watching this and we're on 148, it is your duty to help us to get to 150. I really appreciate all of the amazing comments I've had from people, and the abuse has gone significantly down. So whoever's organizing the absence of abuse, I thank you. Peace out.